Good morning and a very big welcome to Hansuke's webinar on what hedge funds need to know about SFDR. I'm delighted that you're able to join us this morning for what promises to be a great event. My name is Ali Kazimi and I'm the Managing Director of Hansuke. Hansuke is a specialist tax and regulatory firm focused exclusively on the investment management and banking sectors. So in recent weeks, we have had a plethora of announcements from Chancellor Sunak. He's announced that UK is the first country to be introducing a economy-wide climate-related disclosures by 2025. We are the first ones to issue a sovereign green bond. And clearly ESG, impact, sustainability finance is clearly on the agenda and is the rage for both investors and regulators. And just to tell you how this whole webinar came about, we recently hosted a webinar with the SIX, that's the Swiss Stock Exchange guys. And we were discussing the importance of ESG data in the context of ETF investing. And afterwards, a hedge fund principal client of mine came up to me and he goes, John said to me that, you know, I know this is really terribly important, but I'm really confused. You know, frankly, the whole thing seems a bit like a big alphabet soup. And that's really the moment when I thought what we really needed for John was to get a whole bunch of experts just to demystify the area. You know, it's just overwhelming for someone, you know, particularly the hedge fund sector where you've got a smaller staff than say one of the big investment management houses. And so anyway, we got chatting and my friend Mel, and as they say, the rest is history and here we are. So welcome. I really am delighted that Mel agreed to go along with this idea and importantly to moderate today's discussion. Mel, as I said to you, is a good friend and she's extremely highly regarded in the hedge fund community and importantly she's a partner at haysmacintyre. So if you don't know your SFDR from your TCFD, then stick with us for the next 90 minutes and hopefully Mel and her expert panelists will illuminate your journey. Thank you very much. Over to you, Mel.
Thank you, Ali. Very kind introduction. Good morning, everyone. Thank you for joining us. Thank you also to Hansuke for organising this and managing to get together such an amazing panel. As Ali mentioned, today we're going to be discussing the EU Sustainable Finance Disclosure Regulation. 90 minutes of hopefully demystification and getting you prepared for what is to come in quite short order. Ali has already introduced me. I'll be your moderator today. As Ali mentioned, I'm a partner in the financial services team at haysmacintyre, working with largely UK hedge fund managers. So the regulation is applying from March 2021 and is forming part of the EU's package of measures in respect of ESG issues. Clearly, with Brexit on the horizon, there's lots of questions now over its applicability to non-EU investment managers and also how it's going to affect non-ESG strategies. So hopefully we can take a deep dive. The way that the format is going to work today is we have 5 experts in their respective fields. Each will give a mini presentation of their respective area, and then we'll open it up to a fairly lengthy Q&A session at the end. So I'm not going to take questions as we go along, but if you have any burning questions as the presentations are taking place, please do ask the questions as you think of them. And as I say, we'll leave plenty of time at the end. I'm going to leave my panelists to introduce themselves properly, but in turn, we have Rebecca Chesworth of State Street Global Advisors. She's going to use her knowledge of the market to provide insight from a commercial and strategic angle. We have Judy Kuszewski, who is from GSSB and is going to give the standard setters view. Giorgio Botta of EFAMA is going to share his members' opinions and their experiences of the ongoing process from a European perspective. Dani Williams of ACA Compliance will provide a UK regulatory view on the expected direction of travel. And last but by no means least, Tracey from Simmons & Simmons is going to give an overview of the practical aspects of implementation. So I'm going to pass over to my panelists to start taking their deep dive. But before I do, I've got a quick question of my own just to act as a bit of a quick icebreaker. So what have you all done today that is ESG? So mine is I'm hopefully you're going to have something a bit more worthy than mine. I've done a bit of recycling. It is only 11 a.m. So the day is still young. I've done a bit of recycling and I used oat milk on my cereal. So Rebecca, I'm hoping you can beat that.
Well, I did run to the coffee shop. I did take my recyclable takeaway mug. I did put a penny or two in their charitable donation box for a tsunami. I did inquire after the health and well-being of the barista, but I'm not sure if the barista's pay was linked to how good my coffee was, so I'm slightly worried about the governance.
Good effort still. Judy?
So, yeah, I ran an errand in my electric car this morning.
I switched off the lights in the corridor that my flatmate left off.
So I'm actually moving this weekend, so I'm setting up a green energy provider in my new flat as well as my current one. So well done today.
So it's a bit early for me to have done anything massively ESG, but I made my cup of tea in a mug rather than getting a takeaway one, and I've turned my heating off. That's
Bravo. Well done, everyone. Without further ado, Rebecca, can I hand over to you to start giving us some good insight on SFDR?
Yes, of course. Thank you very much. Thank you for inviting me. So I thought I would set the scene and kind of expand on how important this is for the industry and put SFDR in the context of a very busy 2020 and what's likely to be a very busy 21 as well. So I mentioned I work for Spider ETFs. We may be better known as the first provider of an ETF, SPY, the S&P 500 ETF. That was more than 25 years ago. We've come a long way since then and now have ESG funds amongst our range, including screened and best in class. Now, Spider is part of State Street Global Advisor, so that's where it starts to get interesting and very relevant to us about what's happening with this reporting regulation. So we're the third largest asset manager, so that's a lucky thing, because I guess compared with a lot of people on the call, we have got a big resource. But also, I thought it would be interesting to just share with you a little bit about what it's like to work for what's largely known as an index and a passive fund provider, because actually ESG and our role in that is often overlooked. So if we think about what we need to do, we are the custodian, the steward of thousands of shareholdings in many, many companies. So part of that, with that comes a responsibility to provide product to the client base, give them choice, to walk the talk, to ensure that we're resilient, we're stable, we're ethical in the way that we run our environmental footprint, in the way we think about staff. And of course, one of the parts of that role is to educate investors and asset owners. So giving you that many funds, that many assets, gives you a voice in the industry. It does mean that passive providers, and as I said, this is often overlooked, do have a big role in stewardship. We have to hold on to the companies that we have in our funds. We can't sell them out if we don't like them, because we're trying to match the index. So we want the best for everybody, and we try to achieve that via voting, engagement, and influencing, just like an active manager would do. And clearly reporting on investments is extremely important, and the activities and the disclosure that goes around for that. So that's why SFDR is of very, very big importance. And I just wanted, as I said, to put that in context of what has been a period of unprecedented development in ESG. We've been talking ESG investments quite broadly as a community now for at least a decade, but this last year has seen unprecedented change. If we think about the funds flow, and Ali mentioned a previous webinar when we were thinking about some of the trends in ETFs, then ESG was a clear one of those. And we've also seen a lot of new products. We've seen a huge number of corporate ESG bond issuance, new regulations and requirements, and a big improvement in corporate behavior. And what I like is the fact that this has happened despite COVID, despite the problems of COVID, but actually COVID has actually amplified the problems and made people, I think, behave better because of that. So we've seen companies do their part. We've seen companies talk about short-term priorities on staff as well as longer-term climate change priorities. We've seen increased reporting from them, lots more mention of net zero, for example. We've seen investors stand up. So many investors, including people on this call, were already pledging a commitment to UNPRI and other high-level initiatives. But we've seen that increase this year. And as well as that commitment, that pledge, we've seen people take action. So we've seen that resolve itself in how companies are behaving, what they're reporting on, how they're managing things. And then finally this year, we've seen the government step up as well. So in terms of how their regulations, but also if you think about Europe, how we're increasing some green issues within our stimulus package. Very, very interesting was the EU recovery package announced in July. Now, I know that stalled slightly, but very interesting to see that aggregated at that level. And then the other thing that COVID has done, if we're thinking about this year of change and where we're going, is that COVID combined with that social unrest that we upsettingly saw in the US in the summer, means that we've created a lot more interest in the S, the social pillar of ESG. So we're thinking a lot more about health and safety, employment issues, labour conditions, access to medicines, etc. So that's a good thing as well. And if we think about what else has happened this year, of course, on the climate front, which is rather more relevant for the call today, then we've seen increasing concern over stranded assets. We've seen a huge decrease in demand in fossil fuels, which of course helped the performance of many ESG funds. And we've seen more of a focus on carbon emissions. So all very good things. And that pace continues into 2021. And that's really where we start to think about the conversation today. There's strong demand for asset owners continuing, but you'll get more regulatory pressures next year. So everybody needs to be aware. And one of those very big things that is happening is SFDR. So this is a big plank of the EU's Sustainable Action Plan. It's a very big ask for asset managers. And as I said, it's going to take a big change. It's going to take a change in our attitude and our response to reporting, not just leave it as a small part of the business, but really engage in it across the business level. It's going to take a big resource for all of us. And what I think is interesting and people really don't realise is it will affect managers whether they run ESG funds or not. So everybody has some disclosure requirement that they need to confer with. And interestingly, as Ali was saying at the beginning, Europe has led the way again. There's increasing divergence between the regulatory policy in Europe and US. And again, we're leading the way this side of the Atlantic. I won't go into any of the details. I will leave that to the experts who are following me. But yeah, just wanted to impress on you the big task facing all of us. It's going to take many man or women hours to almost just to get started, to start classifying our funds, ensure data availability across the company, to ensure that security of data, the certainty of it. We've got to educate the PMs. We've got to educate the role with how we talk to the index companies. We've got to increase the understanding of governance across the company. So that is a lot of questions, and at that point I will be gladly hand over to someone who may have the answers, starting with Judy. Thank you.
I'll do my best. Thank you. I don't know how many answers I have yet, but I hope over the course of this webinar we'll come to some conclusions about some of them. Thank you very much. And I think I could probably concur almost word for word with Rebecca's views on this subject, because we see this in a very similar way across my day job, but also what I'm more going to focus on today. I'll just give you a tiny bit of background. Personally, I'm chief executive in my day job of a sustainable business consultancy called Sandcroft, which is based in Westminster in London. We work with organizations of all sorts in different industries to help them to create value in their business through sustainability integration. One of the most important and fastest growing parts of our business is ESG integration for investors. And this has certainly exploded in the last maybe a bit more than a year, but not much more than a year. So much of that has to do with just the interest rippling across the sector from the asset owners. Obviously, the pension funds have been at this for quite a long time in some cases, but we're now seeing some of the actions that just multiply the interest and seeing that drive through the financial sector more broadly. What I wanted to talk to you about a little bit has to do with a volunteer job of mine, which is that I chair something called the Global Sustainability Standards Board. This is a technical standard setting body under the Global Reporting Initiative, which is an Amsterdam-based global organization which creates standards for sustainability disclosure for organizations internationally. Most of what you would recognize as corporate sustainability reports globally are derived in some way from the GRI standards, which have been around for over 20 years. And it's an ongoing project. It is a well-recognized practice among larger corporates, certainly. 75%, 80% of the largest companies in the developed markets, largely globally, issue sustainability reports. Vast majority of those use the GRI standards to do it. I chair the technical standard setting board of that organization. Now, the GRI standards are intended to help organizations of whatever industry to identify the impacts associated with their specific business activities and then to report on those impacts. And so there are kind of standard disclosures that describe the business activities of an organization and things like their governance and so forth. But then based on whatever the particular specifics are for the organization, they need to choose topic-specific standards for disclosure and just focus in on the things that are really material for people to understand about their performance. So if biodiversity is not a particularly significant part of what your organization might deal with in one way or another, then there's no expectation for you to report about biodiversity. But you have to have a kind of internal process in order to understand what the impacts might be and how this might align with the interests of your stakeholders, whether they're your shareholders, whether they're your neighbors, your employees, and whomever. In addition to the corporate disclosure standards, there's a proliferation of all kinds of other standards that we see coming up. As Ali said, you know, it is a bit of an alphabet soup, especially if you don't have the kind of the way to get into it. And I'm not going to overwhelm this webinar with a kind of a deep dive into all of them. But what I would like to point out is that there's a series of codes of practice and standards aimed at the financial sector per se, which are quite different from the corporate disclosure standards that I've just been talking about, which are probably more relevant to this subject right now. So Rebecca already mentioned the PRI. The UN Principles for Responsible Investment is one of the most important voluntary organizations in the financial sector right now. I think there are tens of thousands, some 30,000, I think, signatories at the moment to the PRI all over the world. Investment managers, asset owners, banks, insurance institutions, all kinds of organizations have signed up to a simple set of principles that have to do with integrating ESG into investment policy and practices, a commitment to active ownership, commitment to requesting and using suitable ESG disclosures from investee organizations. So that's where the kind of the GRI standards come into that, is sort of requesting that companies you invest in disclose in a suitable way to their operations. And then the rest of the commitment under PRI has to do with supporting the rollout and the institutionalization of these practices across the sector. As I said, there are tens of thousands of signatories to it. Their PRI's focus is on enabling ESG thinking and the advancement of practices within firms and across the sector, and to some extent within funds. At the same time, we now see there's a new standard that's under development at the CFA Institute. This is intended to be. It's not been finalized yet. It's not been created yet. There's been a consultation on the creation of this standard that concluded last month. What they are looking at is a disclosure standard for investment products that purport to have an ESG focus to them, so some kind of ESG relationship. So they don't address the performance of any given product or firm, but instead they help to for investors to answer the question, does this investment product support my ESG philosophy, and in what practical ways does it do this? And it looks at a whole range of different ESG features that might be in that might be embodied by any given investment product. Is it a best-in-class kind of a product? Does it have a specific impact objective? That kind of thing. And then also they will include some disclosures about the specific aims of the product beyond financial returns. That would include things like alignment with personal values or moral beliefs, or minimizing negative impacts, uncovering ESG investment-related opportunity. Things like that will be part of that standard. And the SFDR, in a way, sort of bridges both of these, and while their focus is on disclosure about whatever the characteristics might be of a given investment product, as I think Kate might be talking about later on, it really amounts to kind of a normative standard, because in a sense it sort of obligates the user to integrate ESG in order to disclose about it, and that's where I think some of the practical challenges that we'll start to see. And as Rebecca said earlier, there's going to be a huge wave of activity across the sector to try to just comprehend how does what I am doing intersect with these expectations that the market is now putting on us. To what extent can I quickly create some disclosures that will help to provide that comfort level that people need, while I know that in the long term I still have a lot of work to do in order to embed ESG further into our business, into our investment practice. How can I understand what the expectations of my specific customers are going to be in order to give them more of that comfort level, and in order to respond to it? And I think one of the things that's quite interesting about this is that in the world of sort of responsible investment, there isn't a specific thing that's universal about it. There are so many different things that investors could be seeking to achieve with it. Investors don't all want the same things any more than any of the rest of us all want the same things. And therefore, the emphasis on transparency is extremely important, but it will also, necessarily, it will drive more discussion about what are these expectations, what are the ambitions that people are seeking to achieve now. And how can we, within given contexts, for example, in organizations that that outsource investment management, what's the obligation to deliver on a particular set of ESG outcomes there, where you don't have control over it, where it isn't your activity that's driving it. Those are some of the implementation issues that I think we're going to start to see a lot more work being done within the sector to try to not just uncover best practice, but also to just clarify what's normal practice and how does normal practice fit into emerging expectations and obligations. And oh, by the way, we have only a few years to stop runaway climate change and these sorts of things. So and I think this is one of the things that's interesting about the European Commission and their activity around all of this area, which is very broad, is that they are not only trying to stabilize and de-risk the economy, they're also because these are regulators, broadly speaking, and they're tied to governments that have universal obligations to people. They're also seeking to align these activities with national law and policy, with environmental regulations, and so forth, in order to achieve specific, more sustainable outcomes for society. And I think that's the one thing that is very different from what we see in the CFA Institute, for example, and the IFRS. I won't even go there, but the financial accounting standard setters are very clearly looking at sustainability at the moment as well, within the context of their own purview. But what the EU is doing is sort of bringing that together with societal expectations and their role and obligation as governments, as a group of governments working together to achieve simultaneous goals that I think we probably would all support, but in a very complex way, and in a way that is going to continue to pan out for investors of all sizes across asset classes. And whether or not they're based in the EU, whether or not the sort of the SFDR necessarily obliges given activity from given investors, the fact that there's so much global activity and the need to appeal across all kinds of different borders and so forth, it's a bit of a moot point whether or not the regulation will specifically apply to a given organization or not. They'll still have to take account of it. They'll still have to work out how to implement it. I think I'll pause there, and I think I will hand it over to Giorgio to add yet more context around all of this.
Yeah, thank you very much. And thank you also for the possibility to participate to a very timely discussion on behalf of EFAMA, which is the European Fund and Asset Management Associations. And building to what you mentioned already, we see that the implementation of SFDR is starting or it's already underway. And without a doubt, it's a big opportunity for the financial industry, but also a big challenge. And the objectives are all the right ones. If we really are to achieve the ambitions of the Green Deal, and we certainly are, we really need to get more investors on board. There is no way around it, especially retail investors, which are the most vulnerable, if possible, to greenwashing. And these investors need confidence, they need trust, they need to be able to compare information and make their own decisions. And SFDR aims to do just that. So when it comes to fighting greenwashing, there is also a strong case from a market, from a business perspective. An EU framework has the potential to create a level playing field among market participants. And as Judy mentioned, it also bridges between existing initiatives. And it can encourage a trend that we already observe in sustainable investment. Rebecca mentioned it. It's a very much it's a double-digit growth yearly in the demand for ESG products. So investors are becoming more and more sophisticated in their preferences, and we can only expect this to improve with better awareness, with proper financial education, and also if the findings about the performance of ESG investments are confirmed. So this means that SFDR and regulation in general should really empower and enable investors rather than introducing compliance costs or additional confusion for an investor. So I think it's important to note as a starting point that the implementation of SFDR, but even more broadly, the integration of sustainability factors into the business and into investment decision, it's a process. It's something that evolves. It's not just the compliance itself, but also the outcome, the disclosures themselves. They become more and more detailed alongside the development of methodologies to understand and measure sustainability risks and opportunities, and they become more and more accurate as information starts flowing in from investee companies, thanks also to other pieces of the EU sustainability agenda coming into effect in the near future, such as the disclosures from investee companies under the taxonomy, under the revised NFRD, and so on. So the asset management industry started this process of integrating sustainability considerations before even the action plan and before the proposal for this regulation started integrating sustainability factors at the product level, developing new products, taking measures to tackle the ESG data gap already mentioned, and also developing an ESG risk management framework and educating the investment community and their own staff. So SFDR comes as a big leap forward in what is otherwise an evolving process. And it's an ambitious framework, and this ambitious have to find balance in terms of what level of transparency practically can be achieved we can expect from the industry. So I think we have to look carefully at two things mainly. Firstly, how the regulation is specified, and secondly, what does it take to implement it? So when it comes to the specification, we have that at the entity level, according to the draft technical standards that will go and complement the regulation, asset managers will have to start reporting on a long list of specific mandatory indicators that are intended to capture investments impact on environmental and social and governance factors. So at this stage, also in light of what we said about data, it is far from guaranteed that this requirement will increase trust, will increase confidence and comparability. To do so, these disclosures really have to be relevant, so relevant across different strategies, different products, different sectors, and given all the different preferences that end investors might have. But even more importantly, they really have to be backed by solid data, which we don't have, and yet sufficiently. And without reliable and publicly accessible data from investee companies, these disclosures cannot really be relied upon. And of course, asset managers can use estimations, can use proxies, but to what extent? There are legal certainty questions that this raises, but also about reliability of this information. And this certainly will not really answer the need to fight greenwashing. This is what we think. So this is what we are really trying to achieve. To the benefit of end investors, what we suggest is to adopt a more phased approach, in line with this process that I keep talking about, and also in line with other pieces of the EU Sustainable Finance Framework, all interlinked with each other, the taxonomy, NFRD, the amendments to MiFID, the creation of a single access point for data, and so on. So this is for disclosures at the entity level, but ultimately, the client buys into a product, buys into an investment fund or a pension fund or an insurance product. So looking at the product level, the regulation also introduces some transparency requirements on how exactly a product has ESG characteristics or sustainable objectives. If we look at the classification, Article 8 and 9 products introduced by the regulation. And market participants will have to do that, as mentioned, by March, using a standardized template in line with the objective to provide comparable information to end investors. This template will have to be included in existing documentation, in existing prospectuses. And we have seen, for consultation purposes, we have all seen a proposal on how this templates should look like. And we are talking about a 4 to 6 pages document which contains detailed information really on how, for instance, the underlying assets are aligned with the taxonomy, or how benchmarks are used in line with the environmental objectives, or how derivatives are used, and so on. And personally, as a humble regulatory policy advisor, which focuses on sustainable finance, I already had my fair share of confusion trying to go through the report. I can only imagine the difficulties that a retail client and a less sophisticated client could have. So one reason for that is that templates are trying to address the needs of very different users, retail users on the one hand and professional investors. I think the focus should be on retail investors. And why? Because professional investors already have the tools, the resources, and the knowledge to assess the sustainability of a financial product. And what it's important to do is to see how effective these disclosures are with people that do not speak on or attend a webinar on the integration, on the implementation of SFDR. So we need really consumer testing. So to present these documents to a sample of retail clients and see how to make these disclosures more clear, more understandable as much as possible. This is for the specification. About the implementation, already mentioned, we discussed it with members. It can take up to a year, depending on the size and the resources of the asset manager. It's even longer for smaller ones, this process. And it takes time, it has costs, and we need to look at costs with an holistic perspective. It's not just the cost of retrieving data or other costs like this. It's also training, it's a staff expenses, it's increasing staff, it's the IT infrastructure, it's a whole risk management framework that the company has to implement. And there are still plenty of outstanding questions on how to interpret and implement the regulation. So today we already have speakers that are much more knowledgeable and hands-on experience on this than me. But just to give you a sense, at EFAMA, we are really mobilizing resources to assist members with understanding and with implementing the regulation. And this has to be done by March. And regulators have been responsive to this industry concerns, and they are considering giving more time to implement at least the technical criteria. So this will allow, at least initially, to comply with the regulation on so to say, a principle based on a best effort basis, according to the level 1 text of the regulation itself. So this is, of course, very welcome news. And it's also important that this interim period, regulators also make an attempt and an effort to ensure that the regulation is applied consistently across member states and by national supervisory authorities, which are responsible for that. This is a matter of supervisory convergence, and it's important for distribution. It's important to ensure that the implementation efforts won't have to be duplicated later on. Even more important, it's important to make sure that investors are provided with the same safeguards and the same information independently from when they're based or where they access these products. So to conclude and circle back to the objectives I mentioned, the regulation really has a potential to be a win-win for clients and for asset managers, and also for the EU and for the environment. But it can still be a lose-lose. And there are unresolved issues on its implementation and very high costs that ultimately risk being transferred to end investors, which in turn will not benefit from better disclosures and might be discouraged from taking part in this transition and do this push for green investment. So there are certainly more urgent issues than investment managers' implementation of SFDR today, which we share. Climate change is on top of this list, but this urgency to address these challenges should not take resources away from designing and implementing a well-calibrated framework. So this is what EFAMA is trying to help achieve. I will just stop here and hand over to Dani. I look forward to hearing more from you. Dani, you are on mute.
Apologies, thank you.
We can hear you.
So please, let me know if you can see those slides at the moment.
Yeah, we see the window, yeah.
Perfect. All right, so in kind of taking a step back, so in looking at kind of, I guess, the current state, kind of the ESG landscape within the UK, not to spoil the ending, but we do know with SFDR that due to Brexit, it's not going to be onshore to the UK come the 10th of March, just specifically for those managers. So perhaps it's best to kind of take a step back and look at kind of where we are at this moment, and then from a UK perspective, what we can almost kind of anticipate or hopefully foresee in the future with incoming ESG regulation. So as it stands, as at this very moment, ESG kind of is a very kind of ad hoc nature, shall we say. There is no formal regulation, obviously, in kind of any of the major financial markets that kind of regulates ESG. Everything is kind of done on a best efforts approach. There are obviously several different drivers for this. You've got either membership or on a voluntary basis. So for ESG credentials, or those firms that choose to kind of be ESG, oftentimes they're a member of one or several kind of voluntary groups. I know we've touched on quite a bit the UNPRI being one of substantial popularity for just kind of all firms. So that's kind of one element. Within all of these kind of various groups too, there are different standards and adherences. So depending on what kind of focus you have in the ESG sphere, you may, again, be a member of one and or several. We've got a lot of guidance that's recently been coming out regarding what to kind of look for, what is deemed kind of to be ESG friendly. So we've put kind of a couple of down there, but it's forever kind of, you know, new advice being given, new best practices kind of out there. But no real kind of cohesive legislation from a UK standpoint as to specifically what is mandatory and what firms need to do. Kind of a huge issue too within this area is that when we talk to a lot of our clients, this space tends to be hugely investor driven. As part of that too, though, what people consider as ESG, what people want as ESG, how they view ESG is all kind of varying in nature. So depending on kind of your investor base, you may get, you know, one firm that's heavily, you know, one kind of investor type that's heavily driven towards carbon neutrality and climate change, whereas others want the full scope of, you know, ensuring good governance and human rights also as important drivers within there. So unfortunately, this has kind of led to increased global pressure for kind of consistency and accountability within the space. Kind of just to kind of run through more like driving and what we've kind of been seeing and why it's so important. Just looking at the past few years, you know, as to how much we've seen kind of the ESG space grow. And just not only from, you know, an environmental standpoint of having that as a driver, but just even taking it back from a purely like financial regulatory space of, you know, how many more investors are getting involved in this space and how much more need for clarity that there is in practice. Also too, kind of carrying on from that, and I know several of my fellow panelists have already kind of touched on this, within the ESG space, we currently have a lot of competing reporting frameworks and guidance. Maybe competing is the wrong word, but within each one of these areas, be it, you know, governmental organizations, NGOs, independent bodies, there are kind of really good goals, metrics, however you want to put it, but the kind of, there's no kind of consistency, and there's no kind of mandatory requirements for all firms who are claiming to be ESG to sign up for to do. You know, some, and I know these bodies have actually been a little bit criticized for, you know, having not enough teeth and all going far enough kind of within the ESG space. There's also, you know, again, just within this tiny slide, and I know, forgive me, this is a fraction of kind of, you know, all the bodies that are out there, but, you know, we've also got the kind of competing nature of ESG versus impact investing, you know, and getting investors to understand kind of the underlying, the difference within that. So unfortunately, kind of none of this, be it of an ad hoc nature, kind of goes far enough to kind of integrate all the kind of ESG standards in order to kind of formulate a cohesive, understandable kind of process within products in a firm. So moving on to kind of the future of ESG regulation, and as I kind of touched on to begin with, we do obviously have SFDR coming into place, you know, in March of next year. But as a result of Brexit, SFDR has not been onshored by the UK. So although this will not be applicable to UK managers, obviously given the close ties with the EU, you know, this will still be applicable to a vast number of firms over here that either market into the EU or have some sort of presence within the EU. So it is still hugely, hugely relevant. And just to kind of also, the next kind of bit is that's hugely kind of now out there and being espoused by the government is potentially kind of next phases or next steps in kind of achieving a kind of cohesive ESG regulation within the UK. We've got the Task Force on Climate-Related Financial Disclosures, which is due in 2022. So obviously, even looking at kind of both of these, I'll just kind of quickly touch on some of the differences. You know, obviously we've got this SFDR, which is basically been introduced to kind of integrate sustainability risk and investment process, as well as, you know, provide investors with disclosure on such risk. You know, there's obviously, we've got the level 2 in the taxonomy requirements, which initially, and the reason for pending is obviously we've got a brief pause in those coming into play. And also the UK had officially, when talking about potentially adopting this, there was some discussion on whether or not level 2 would ever be, level 2 in the taxonomy requirements would ever kind of be fully adopted. Obviously there's been discussion around kind of those requirements potentially going a little bit too far. You know, there's, you know, Giorgio just touched on, you know, a lack of ability for data being present to report on some of the metrics that the regulation's currently kind of requesting. I guess the good thing about the SFDR though is it is one of those regulations that is kind of all-encompassing within the ESG space. So a lot of focus kind of within ESG is obviously on carbon and carbon neutrality and green initiatives, but SFDR really does focus on the E, the S, and the G. Kind of the downside is that it's hugely, at the moment, just an EU-centric regulation. So whether or not the kind of UK chooses to kind of onboard and adopt this a little bit more, kind of moving forward, I guess shall kind of be seen. The next kind of potential where we see ESG regulation going is, again, in regards to the Task Force on Climate-Related Financial Disclosures. At the moment, this is considered kind of good guidance and has been espoused of, you know, something firms should definitely start considering. And there's been comments by the government to basically expect this to become kind of mandatory reporting come 2022. The kind of, I guess, downfall to kind of this area and this regulation is that it's more focused on your kind of environmental impact. Which obviously opens up a huge another world when you start talking about, you know, the wider world of ESG regarding, you know, the social and the governance aspect of it. The task force is also meant to, you know, provide kind of greater clarity and consistency on language around disclosure requirements, which is obviously, again, at least I think with all these regulations, what we can say is that the primary driver is disclosure to the investor. so that they can begin to kind of fully understand, what it actually ESG firm means, what it means to be ESG. Also to the Task Force on Global Climate-Related Financial Disclosures, this tends to be a little bit, it's a wider global base. So in moving towards maybe what could be a more wider global framework and a universal understanding of what it means to be ESG, the Task Force on Climate-Related Financial Disclosures is getting a little bit further down the line because there's more kind of signatories that have signed up for it, as opposed to SFDR, which right now again sits hugely kind of just within Europe. So that being said, this is kind of like without giving away the government's guidance or where they're going to kind of choose to take it. As my fellow panelists have kind of already said, there needs to be some kind of clarity and cohesion around, what is ESG, with all the information out there, with the potential reporting requirements, the various bodies and the various ways that, everyone kind of looks at how this is done, we definitely need to kind of come to some consensus. And so looking into what potentially we can see coming from the UK government in the next year or two regarding what regulation to kind of expect, we kind of focus on these two. And the reason for that is kind of mainly around, this has been the kind of recent comments from John Glenn MP, who tends to be involved in a lot of these areas. So the Economic Secretary to the Treasury, his comments to the Investment Association on Sustainability and Responsible Investment in September was, to this end, I've been clear at the very least, we will match the ambitions of the EU Sustainable Finance Action Plan, and we will say more about that in due course. Obviously, this is in Spouse's SFDR taxonomy regulations, and where we kind of initially kind of saw this heading. The next comments in November of this year, in relation to specifically to the TCFD and their interim report, the foreword by Mr. John Glenn, the expectations of all UK listed issuers and large asset owners would be making disclosures in accordance with the TCFD's recommendation by 2022. At this time, we said we would consider the case for mandatory requirements to ensure the economy moves to a full TCFD-aligned disclosure. So basically, from a UK perspective and a regulatory perspective as to what we can kind of plan on moving forward, until we kind of get a more firmer signed into law kind of practice, the regulation seems to be moving kind of into some sort of hybrid direction of, compliance with an SFDR, especially given kind of the close ties and the overlay within the European jurisdiction, and then also within the TCFDs. And again, we'll kind of see how that kind of works out. And if those gaps can kind of be bridged between the TCFDs kind of have a focus, kind of more on the environment, and then the SFDRs more kind of technical kind of reporting requirements that firms seem to be, kind of concerned about or potentially will struggle with in the future. So unfortunately, that's kind of where we're left from a UK perspective as to what to anticipate from an ESG regulatory standpoint within the UK. However, that being said, and just moving back to SFDR, this will still impact a vast number of firms within the UK. And so there will be a number that need to start complying, and whether or not, the UK then decides to kind of adopt that, as previous comments were made, more into regulation, I guess time will tell. But I guess on that note, as to what to potentially anticipate, I will pass it along to Catherine to give you the details.
Thanks, Dani. I'm just going to hopefully show my slides. Can you see those slides now, hopefully? Yeah. So just to introduce myself briefly, so I'm Tracey. I'm a lawyer in the financial services team at Simmons & Simmons here in London. I primarily focus on hedge fund managers, so I advise a lot of hedge fund managers around their fund structuring, setting up funds, a lot of their day-to-day fund work. But I also provide advice to institutional managers, and in the past few months in particular, I've been involved in implementation of SFDR projects for institutional managers who have generally tended to be a little bit further ahead in their implementation than hedge fund managers. So it's been a great opportunity to see how firms are progressing with getting SFDR projects in place, and the key issues that are cropping up, the key questions that are cropping up. So for today, I can hopefully. So I thought today I would focus on some of the key practical considerations for firms. So some of the key decisions that they're going to need to make, some of the key policies they'll need to implement. And then I also thought that it'd be useful to just touch on a few of the key questions that I've been finding our clients have been asking around the SFDR. So to start with the practical considerations, so the SFDR will require firms to implement policies, and those may be completely new policies, or it may be a case that you've got existing policies and you just need to update those policies. So from the outset, you'll need to establish to what extent your firm already has existing ESG processes, existing policies, and look at the extent to which you need to upgrade existing policies, or whether you need to actually implement completely new policies. Obviously, you'll need to work out exactly who is going to be responsible for the project, what kind of working group you're going to need, and then thinking of your stakeholders. So who are you going to need to engage internally within the firm? What involvement are you going to need from external service providers, from investors, regulators? And then I think one of the key themes that will come through when I'm looking at some of the key obligations that firms will need to comply with is that the SFDR will require updates to your fund documentation to include the mandatory disclosures that are required by SFDR. And so you will need to be thinking about A, which products are in scope, but B, what's the process to update my fund documentation to include the disclosures that are necessary, and do we need any form of investor notification, investor consent? Do we need to notify the regulator? How long is that going to take? How much lead-in time do we need to build in to make sure that we can do this and get these disclosures in place by the deadline of 10th of March 2021? So looking at some of the key requirements, so starting with the requirements that will apply at a manager level, at a firm level. So the SFDR will require that all in-scope firms implement a policy on the integration of sustainability risks into their investment decision-making processes. So essentially that is, how do we integrate sustainability risks into our investment decision-making processes? What is the potential impact on value of our investments of those sustainability risks? So again, you'll need to look at whether you've got an existing policy. If you've got an existing policy, look at that policy against the level 1 requirements and work out the extent to which you need to upgrade that policy. If you don't have an existing policy, then it's going to be a case of drafting a policy, making sure that you get that policy in place by the time required. And then again, from an internal perspective, consider the process for updating your policies internally. What kind of consents do you need? How much lead time do you need? And make sure that you are updating and providing the various required disclosures. So the SFDR requires disclosure of the policy both on a website, but also you need to include a disclosure of that policy in your financial product disclosures. And then talking about, so the second key policy requirement that's imposed by the SFDR is this requirement to have a policy on how the firm considers the principal adverse impacts of its investment decisions on sustainability factors. So this requirement is, for most firms, will be a comply or explain requirement. So firms will need to make a decision as to whether or not they are going to implement that policy. The slight caveat to that is that for certain firms, so if you've got more than 500 employees, or if you're in a group with more than 500 employees, that will become mandatory from the end of June. So as a practical decision, you'll need to decide whether or not you are going to implement that due diligence policy, or check whether you're automatically caught by that mandatory requirement. So if you are going to comply, then again, you'll need to benchmark the policy that you already have if you have an existing policy. If you don't have an existing policy, you'll need to begin a project to draft that policy. If you are not complying, then you'll need to think about what are the reasons that we don't consider the adverse impacts of our investment decisions on sustainability factors. So the SFDR requires firms, if they are not implementing that policy, they need to publish the reasons why they don't consider those adverse impacts. And again, you'll need to include disclosures in product documentation. And then the final element that I wanted to touch on from a manager level is that the SFDR requires firms to ensure that their remuneration policies include information on how the firm's remuneration is consistent with the integration of sustainability risks. So we're expecting that this will be a relatively limited update to your remuneration policies, but you will need to review your remuneration policy and consider the extent to which you need to include any new wording in that respect. And then to look at some of the key product level requirements. So the decisions that you're making at firm level will then flow down into your products. And I think that the key point to note here is that some of the product disclosure requirements that are imposed by the SFDR will apply to all in-scope products, regardless of whether they have any kind of ESG focus. So there are certain mandatory disclosures that need to be included, regardless of whether that product has an ESG focus. So, you know, it's not just funds which take into account environmental, social, governance factors. There is an impact on all relevant funds. So the first key requirement at a product level is this requirement to assess the impact of sustainability risks on returns. So for each product that you have, you will need to make a decision as to whether or not that product will assess the impact that sustainability risks would have on the returns of that product. So that the risks, the impact those risks would have on the value of that product's investments. Or if for that product, the manager thinks that sustainability risks aren't relevant, in which case you'll need to include disclosures of the fact that you don't consider sustainability risks to be relevant to that financial product, and why you don't consider those risks to be relevant. So again, it's various decisions that need to be made. You'll need to establish where in the firm those decisions are being made. Are they being made at a management level, or are they being made at for example, by the portfolio managers of the relevant funds? And then if you are assessing the impact of sustainability risks, then you will need to include a disclosure as to the impact that you expect sustainability risks can have on the returns of that financial product. And we're expecting that initially most firms will just provide narrative disclosure of those potential risks and their assessment of what the likely risks are on that financial product. And then the second element to consider, again, so this flows down from the decision that's been made at manager level as to whether or not you will have a sustainability due diligence policy. So whether you will be considering the principal adverse impacts of your investment decisions on sustainability factors. So if you have decided to implement that policy, then at product level, you will need to make a decision for each product as to whether or not that specific product will consider adverse impacts of investment decisions on sustainability factors. And then you will need to disclose the extent to which that product considers adverse impacts, or if it doesn't consider adverse impacts, why that decision has been made for that product. And again, there's a negative disclosure requirement. So if the manager is not implementing that sustainability due diligence principal adverse impacts policy, you'll need to disclose in your product disclosures that the manager does not consider adverse impacts and why it doesn't do so. And then the final bucket of products is those products which have an element of express sustainability focus. So this is one of the elements that I've been finding firms have been focused on at this stage, and it's raising a lot of questions from firms. So for all the products that are in scope of the SFDR, so any product which falls within the definition of a financial product for SFDR purposes, you'll need to establish whether that product falls into, so there's a three-tiered hierarchy. So I've seen it referred to as dark green, light green, and other. So Article 9, those products which have sustainability as their investment objective. Then you have Article 8, which are products which, so light green, which promote environmental or social characteristics. And then you have those other products which don't have that express sustainability focus. So for all your products, you will need to go through an exercise of categorizing into those three categories. So that's quite a big job. And because of the specific requirements to fall within the categories that are set out in Articles 8 and 9, we're expecting that firms may need to make some tweaks to their products. If they have a particular product, for example, that they think should fall within Article 8, it may be that they need to make some tweaks to ensure that that product meets the criteria to fall within that Article 8 category. And then once you've made those categorizations for those products which have the express sustainability focus, there are additional disclosures which are required. So just touching then quickly on some of the key questions that we've been finding are coming up. I won't talk about the UK as Dani has touched on that. But one of the key questions we're finding at the moment is, so there's, because of the delay to the implementation of the level 2 technical measures, what's the impact of that? What does that actually mean for us? It's superficially, initially, it seems like a helpful development. So, there's no requirement to comply with those detailed level 2 requirements, but you are still required to comply with the level 1 requirements. So you need to make sure that you are looking at those level 1 requirements, comply with those requirements on a principles basis, a best efforts basis. But what you don't have is that requirement to comply with those detailed level 2 obligations. So regardless of the fact that we don't have the detailed level 2, you do still need to ensure that you are complying with the level 1. And then just to touch on one of the other questions on this slide, one that comes up quite a lot is whether or not non-EU AFIMs will be in scope. And I think, again, as Dani potentially touched on in her talk, for non-EU AFIMs, if you're marketing your product, so your AIF, into the EU, then you are going to be in scope of those product level requirements in relation to those products which you market into the EU. And with that, I will hand back to Melanie.
Thanks, Kate. Thanks, everyone. Very insightful, lots to get to grips with. I guess just moving on to, we've got some questions. if firms haven't yet made very much headroom with readiness for SFDR, have they left it too late? Are there any kind of quick wins?
So no, I'll take that one if that's okay. No, I don't think it's too late. I think, you know, it's key that firms do engage with this and begin to implement the policies that are needed, begin to think about the product level disclosures that are needed. But no, I don't think it's too late. You know, you are, for March, it's a case of complying on a best efforts basis with the level 1. So we've been working with firms to provide template policies. We've been assisting them with those categorization exercises. We've been assisting them with understanding the nuances of the rules. So absolutely, I don't think it's too late. I think you know, it's get going, but but you know, there's still a few months.
Still time. And I guess kind of more broadly for the rest of the panel, is there a risk that we're being a bit too ambitious with this regulation? It seems as the kind of eventual scope is pretty huge.
Yes, maybe I can take this one. And indeed, the ambition is great, and it's something we share. But the timing and the implementation and the cost, it's a very detailed. We have seen in the presentation. It's very detailed requirements, which puts a lot of pressure on companies on integrating these rules and being transparent about these rules in a way which is credible, which is reliable, and that builds upon data that are still not coming there. It's also a matter of making all the rules, if we still want to look at regulation. It's a matter of making all the rules and the EU Sustainable Finance Agenda work together in an efficient and coordinated way. And there are pieces of regulation that respond to these questions about data, about information from investee companies, which have to come into effect. So a phased approach would also help bridge this gap and make things more efficient and easier for the industry. Ultimately, the goal is to have disclosures and transparency that is credible and fulfills the objectives. Otherwise, the ambition only creates costs and uncertainty.
I was going to add that I think we've all said how ambitious it is, but it was interesting to hear from Dani about the UK and what might happen there, because even worse, or even more taxing would be for UK managers who are having to comply because they're selling to Europe or their funds are registered in Europe, and then at the same time you get a different regulation coming from the UK. I mean, so there could almost be more of an ask to come.
So Matt, we know that obviously there were several industry bodies within Europe that actually petitioned the EC to postpone this, like as in not just lighten it to a principle only basis, but literally postpone it because they don't think they're going to be ready in time. Now, obviously speculation on my part, but you know that there's almost some maybe sense or feeling or potentially that the UK government also sat there and went, this is going to be too taxing. Do we really want to jump through the hoops of potentially implementing something that, you know, we don't think we're going to be able to comply with, that is maybe too onerous? So maybe let's take a step back and relook at it, which is then where we get to the TCFD, which is a lot lighter touch and more climate focused, which helps meet the objectives of, you know, the Sustainable Development Goals and the EU MPRs and all of that. But it's a lot lighter touch than SFDR. At the same time, though, they've made comments to kind of both the facts that we're going to do something in this space, but I guess kind of only time will tell, I guess, how they're kind of thinking about it, unfortunately, for those of us that do this for a living and trying to get to grips of, you know, how to advise our clients and telling them what's coming down the pipeline. You know, as of a few months ago, we thought, you know, SFDR was going to be applicable. We thought we were, you know, going to onboard it, and, you know, now we're not, and we're hearing kind of, you know, conflicting information. So I guess we'll see.
Thanks, Dani. And I guess obviously we've talked today about EU requirements. what is the rest of the world doing? You know, clearly, new president-elect Biden, we all know how he stands on the topic of climate change. Presumably, there will be more of the same to follow elsewhere in the world.
Shall I have a go at this and see where we go? Yeah, I mean, it will certainly have some effect to some extent. There's no real question about that. The fact is that the US SEC is very much sort of driven by administration policy, and therefore their responses are likely to be quite different from what they have been for the last 4 years or so. That being said, the structures within the U.S. government and administration don't move very quickly at all, and there might be some areas in which I think I would agree that TCFD style disclosures will be encouraged by the SEC and maybe some other regulators in certain contexts. I'd be surprised if it was rapidly made mandatory, and certainly something that is as ambitious as the SFDR. I don't see that happening. Maybe there'll be pieces that you will see in some policies or other. The Far East. I mean, I think there's, you know, there are plenty of examples of stock exchange listing requirements and you know, sort of specific obligations in particular countries that suggest that there's a real sort of concerted effort that's underway at a global kind of financial level. But again, the kind of the coordination between different governments and so forth is just not nearly as strong as it is in Europe, and therefore the ability to take a big step and to do it quite quickly and decisively, it just doesn't translate in other parts of the world. I mean, it will have reverberations across the world. It will cause a lot of multinational businesses in particular to consolidate their efforts and to be consistent in their global approaches. But I think the global sort of regulatory picture will continue to be piecemeal.
Thanks, Judy. And I guess this is probably just the start. So what can we expect in, say, the next 5-10 years? Any insights from any of you who want to look into your crystal ball? Go on, someone be brave.
I'll be brave. I guess a little bit of that is, unfortunately, to kind of go back to what I said, we don't actually know. You know, again, I would say 6 months ago, you know, we were looking at our clients and talking about, you know, what the steps they should be taking for SFDR, because, you know, based on government comments, we thought it was, you know, going to be adopted, you know, and everyone was fairly on board with that. And then kind of, you know, as time progressed, you know, nothing happened. You know, now they seem to have shifted focus to, you know, the TCFD and, you know, oh, we're going to do it this way kind of approach. You know, those comments that I showed were literally within, you know, 2 months of each other. But kind of both of those standards are a little bit different. So I guess, you know, unfortunately, I think maybe there's waiting to see how SFDR actually does play out in Europe. Is it going to be as onerous and taxing on, you know, managers there, and then taking a step back and seeing, you know, what works and what doesn't, and then we'll adopt that approach. Maybe having, you know, having everyone else do the trial by error, and then we'll see and officially kind of, you know, rubber stamp where we're going with this. All the kind of commentary and guidance that has come out, you know, it is fairly consistent about, you know, what we're kind of looking to do from a UK perspective. You know we need disclosures. We know they need to be detailed. You know, we know investors are kind of, you know, in the moment kind of a little bit in the dark as to what, you know, ESG is, what they expect of managers that claim to be ESG. But again, it's that, and I hate to say it to give myself kind of more work and everyone kind of on this panel, but we do need a thorough, cohesive regulation that kind of lays out in detail, you know, how this is going to look and be implemented within the UK. And unfortunately, back to my just don't know. hopefully it's coming soon. I hate to say it, but again, I think the guidance and just having a clear picture would be beneficial in this scenario, rather than, you know, the kind of back and forth or trying to kind of understand what we should be doing. I don't know if anyone else agrees from a more practical standpoint.
I was just going to say, I agree, definitely more work, and definitely from what we've seen this year, an acceleration. But I guess we can look at the good things as well, because I think the more we talk about it, the more we educate people. That's key. I have a question, if I may, but I'm not sure who I'm going to put it to, maybe to Kate. But I'm intrigued on the Article 8, Article 9. So, you know, I sit here as someone who represents lots of funds, and, you know, there's the question as to which are 8, which are 9, etc. And I wonder, on the one side, you know, will companies be saying, oh, we've got lots of 9, really dark green companies, and that becomes a promotion, a good selling point? Or will we, on the other hand, be saying, oh, well, maybe we don't want that many, because the reporting requirements are going to be huge on these, and we're putting ourselves out there saying we're doing this. So I'm intrigued as to kind of what conversations people are having around that.
So, I mean, from what I've seen so far, firms generally are finding that, you know, the Article 9 is a very limited subset, so they don't have many products which fall into Article 9. The good governance requirements which SFDR imposes in respect of Article 8 and Article 9 products, that's a new requirement in relation to the investments of those products. So we're generally finding that people will need to make tweaks to their products if they want them to fall into those Article 8 or Article 9 categories. I think the difficulty that people have at the moment in categorizing their products is that there's not very much guidance in the level 1 text around what the nuances are between an Article 8 product, an Article 9 product, and a product which doesn't fall within 8 or 9. Whereas the level 2 text, although it didn't set out explicit definitions of those, the recitals did give some helpful information that could be used to feed into those decisions. And so what we're talking to clients at the moment about is whether they still should look to those recitals in the level 2 when they're categorizing their products. And as a general rule, we're saying, look, regardless of the fact that the level 2 isn't coming into play, we think that you should still take into account the information that's set out in those recitals, because I think the risk that I've found a lot of clients are concerned about is that they don't want to over-categorize. So they don't want to over-categorize because they're just looking at the level 1, categorize a product as Article 9 or Article 8, and then find that when the level 2 comes in, they look at the specific requirements in the recitals, any additional information that's in the final level 2, and they find that actually, no, this product doesn't actually fall into Article 9, and then that is going to be not a good thing from an investor relations standpoint if you're having to go out to clients and say, actually, we categorize this as Article 9, but actually now that we've seen the level 2, it's not, and we have to walk back that categorization. So it's a big issue for firms, but we are seeing firms kind of generally, you know, the Article 8 and Article 9 products are a limited set of products.
Thank you, that's helpful. Thank you, Kate.
Thanks, everyone. I think that's about it for questions, and we are rapidly running out of time. So just want to thank all of my panelists again. It's been a really helpful overview. Thank you to our audience, and thank you once again to Hansuke. If any of our audience do have any questions that they didn't feel brave enough to pose today, do feel free to reach out to our panelists directly or via Hansuke. This session's been recorded, so if anybody missed the start or wants to watch it again or share with colleagues, then I'm sure that will be shared, but feel free to get in touch with Hansuke as well and they can pass that on. So thank you all once again, and hope everyone has a good rest of day.
Thanks.
Thank you very
bye.
much. Pleasure.
Bye, everybody.